business. Today, the subcommittee is meeting to hear testimony on H.R. 4715, the Quapaw Tribal Landowner Settlement Act of 2021, introduced by Representative Mullin of Oklahoma. Chair Grijalva of Arizona's H.R. 5715 to reauthorize the Morris K. Udall and Stewart L. Udall Trust Fund and for other purposes. In H.R. 6707, the Advancing Equality for Wabanaki Nations Act, introduced by Representative Golden of Maine. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member. This will allow us to hear from our witnesses sooner and help members keep to their busy schedules. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Without objection, the chair may also declare a recess subject to the call of the chair. Hearing no objections, so ordered. As described in the hearing notice, statements, documents, and motions must be submitted to the electronic repository at hrnrc.docs@mail.house.gov. Additionally, please note members are responsible for their own microphones. As with our in-person meetings, members can be muted by staff only to avoid inadvertent background noise. Finally, members or witnesses experiencing technical problems should inform committee staff immediately. I'll begin by recognizing myself for my opening statement. Good afternoon, and thank you to all our witnesses for joining us here today. We'll hear from members of Congress and witnesses regarding 3 tribal bills. The first bill we will hear today is H.R. 6707, the Advancing Equality for Wabanaki Nations Act, introduced by our colleague, Representative of Maine, Jared Golden. Currently, the Wabanaki tribes are excluded from many laws that benefit other federally recognized tribes across the United States, creating an unfair system for tribes in Maine. In 1980, the Maine Indian Claims Settlement Act, also called MICSA, exchanged land between the United States and the Passamaquoddy tribe, Penobscot Nation, and the Hulton Band Maliseet Indians. This exchange provided trust funds for the tribes to purchase land and provided general revenue and old age pensions for their members. Simultaneously, the Maine Indian Claims Settlement Act blocked any federal laws from applying to Wabanaki tribes if it would affect the application of state law and extended civil and criminal jurisdiction to the state by ratifying the state-level Maine Implementing Act. Representative Golden's Advancing Equality for Wabanaki Nations Act would not change the applicability of existing federal law, but H.R. 6707 will update the Maine Indian Claims Settlement Act to ensure that the Wabanaki tribes benefit from any future legislation that benefits Indian country. H.R. 6707 represents years of negotiations between the Wabanaki tribes and the state of Maine. I also want to take this opportunity to welcome the Chiefs who are here to testify on this bill. Welcome. Our second bill will be H.R. 5715 to reauthorize the Morris K. Udall and Stewart L. Udall Trust Fund, introduced by the chair of the full committee, Mr. Raúl M. Grijalva of Arizona. The Udall Foundation is a federal agency established in 1992 by Congress to honor Morris K. Udall and his legacy in supporting the environment, public lands, natural resources, and self-governance of American Indians and Alaska Natives. The Udall Trust Fund provides scholarships, fellowships, and internships for students working within the environmental fields, American Indian and Alaska Native healthcare, and tribal public policy. It's such a wonderful resource to all of us. Additionally, the foundation supports Native American and Alaska Native leaders through the Native Nations Institute for Leadership, Management, and Policy. It promotes the Udall Center for Studies in Public Policy for research on environmental and indigenous policy. increases opportunities for youth to experience our nation's parks and wilderness through the Parks in Focus program. Lastly, the foundation brings stakeholders together to collaboratively build a consensus through their conflict resolution services through the John S. McCain III National Center for Environmental Conflict Resolution. This legislation would reauthorize the Morris K. Udall and Stewart L. Udall Trust Fund through 2029 and increase the funds allocated towards expenses to ensure they can continue to support meaningful work in their programs and services. And finally, we will hear testimony in H.R. 4715, the Quapaw Tribal Land Owner Settlement Act of 2021, introduced by Representative Markwayne Mullin of Oklahoma. H.R. 4715 will authorize appropriations to the U.S. Department of the Interior for payments to Quapaw tribal members following the United States Court of Federal Claims recommendations. The tribe began pursuing litigation against the federal government in 2002 for mismanagement of tribal resources and environmental damages to their lands. After nearly 2 decades, the tribe reached a settlement agreement with the federal government made public in 2019 by the U.S. Court of Federal Claims. This bill will finalize the settlement agreement terms by enacting the recommendations provided to the U.S. House of Representatives. Thank you to our witnesses and bill sponsors for taking the time to testify before the committee. I look forward to hearing the testimony shared this afternoon. I would now like to recognize Vice Ranking Member Obernolte for his opening remarks. Mr.
Thank you. Thank you very much, Madam Chair, and thank you for your kind words in honor of our friend Don Young. It's certainly an honor for me to be filling in for Don here at the hearing today, but his presence will be deeply missed. He was a mentor to me, and I know a mentor to a lot of those, not just in this committee, but also in Congress. I will miss his booming voice. I will miss his deep knowledge of all things related to Indian affairs and related to the state of Alaska. And I'll certainly miss the tap of his cane on the chair in the back of the chamber and his voice calling out regular order, as he did nearly every time that he cast a vote in the chamber. Don, we will miss you. I am honored to be at this hearing with you today. We're going to be considering 3 bills, as the chair has said. I think that these bills are all very timely. Our first bill, H.R. 4715, would authorize $137.5 million to be appropriated by the Secretary of the Interior to pay the Quapaw Nation tribal members in accordance with the 2020 recommendation of the review panel of the United States Court of Federal Claims. And just to remind everyone, in 2012, the House passed a resolution directing the Court of Federal Claims to review this particular claim. And this is the result of that process. It certainly had a lot of due diligence. It's had a lot of stakeholder engagement. I'm very glad that we're finally going to come to a resolution on this issue. On the second bill of our agenda, H.R. 5715 would reauthorize the Morris K. Udall and Stewart L. Udall Foundation Act through the year 2029 and would authorize the foundation to use up to $5,000 for official reception and representation expenses. I think we're all familiar with the good work of the Udall Foundation. They have, since 1992, been working to strengthen appreciation and stewardship of the environment, public lands, and natural resources, and also to strengthen Native nations and facilitating their self-determination governments and they're meeting their human capital goals. It's certainly a very worthwhile foundation, and I'm looking forward to supporting that. The last bill on our agenda today is H.R. 6707, which would make several amendments to the Maine Indian Claims Settlement Act of 1980. Now, just as a reminder, that was a settlement to extinguish the legal claims of the tribes in Maine to their historic lands in Maine. In addition, in compensation, the state offered quite a few different guarantees. I'm a little bit troubled by the action that the committee is contemplating taking today. I think it is critically important that we engage the state of Maine in making any modifications to the Maine Indian Claims Settlement Act. And so I'm looking forward to hearing the testimony of our witnesses and hopefully getting some of my questions answered and our concerns addressed as respects that bill. So I'm looking forward to the hearing, and I want to thank our panelists for being here. That concludes my opening statement. And Madam Chair, before you introduce the panel members, I'd like to ask unanimous consent to enter into the record a statement from Representative Mullin on the bill that he has authored, H.R. 4715.
Without objection, so entered.
I yield back.
Now I would like to give any sponsoring members of Congress the opportunity to speak on behalf of the legislation. The chair now recognizes the gentleperson from Maine, Mr. Golden, for a statement on his legislation.
Thank you, Madam Chair. Madam Chair and Ranking Member, thank you for holding this hearing, for this opportunity to testify about the Advancing Equality for Wabanaki Nations Act. The Wabanaki tribes in Maine are subject to one of the most restrictive settlement acts of any federally recognized tribe in the country. Part of the Settlement Act blocks any federal law enacted for the benefit of Indian tribes from applying in Maine if that federal law would affect the application of Maine state law, unless Congress specifically makes that federal law applicable in Maine. Out of the hundreds of beneficial tribal laws passed by Congress in the last 40 years, Congress has acted to apply only one of them specifically in Maine, and that was this year's reauthorization of the Violence Against Women Act. There are many examples of how this hurts the Wabanaki. In 2010, for example, Congress passed the Indian Healthcare Improvement Act, which allows tribes to employ medical professionals who are licensed in another state. A few years later, the Passamaquoddy tribe relied on that provision to recruit 2 pharmacists. But because hiring those pharmacists would affect state licensing requirements, the state used MIXA to attempt to block the Passamaquoddy from doing so. This is an example of government regulation placed squarely between patients and healthcare providers, for no reason other than the desire of a bureaucracy to maintain regulatory control. The bill before you today proposes a modest fix to address these types of problems. Specifically, it would ensure that future federal laws enacted for the benefit of Indian tribes apply in Maine. This is an intentionally narrow approach. It doesn't go back and apply this change to laws that are already on the books. This bill will cut through unnecessary red tape and bureaucratic efforts to block the Wabanaki tribes from benefiting from future federal laws passed for their benefit and create opportunities for improved standards of living and economic growth. What these tribes want is what all communities in my district want: economic opportunity for their families and safer and healthier communities. None of these tribes want to harm industry or put people out of business. In fact, many tribal members work in logging operations or at mills in my district, and some work directly with members of the Maine Forest Products Council testifying today. In short, they share an economic interest in the success of the forest products industry. You may hear testimony that this bill could lead to overregulation of water quality in Maine. That is factually incorrect for 2 reasons. First, this bill only affects the application in Maine of future laws that Congress may pass. Laws like the Clean Air Act and Clean Water Act are already on the books and do not require reauthorization, so our bill does not implicate them. You may hear hypothetical debates about the impact of future amendments to the Clean Water Act, but the members of this subcommittee know that since the 1980s, the provision of that law that treats tribes as states for some purposes has been amended only once. Further, we can provide the committee with a memo from the Nonpartisan Congressional Research Service that dispels hypothetical scenarios of amendments to the Clean Water Act passed after our bill, somehow making other previous tribal provisions of the law applicable in Maine, and we will be submitting that for the record and providing it to your staff. Second, the issue of water quality in tribal waters has already been addressed in Maine. In 2019, Maine and the Wabanaki tribes reached an agreement on water quality standards that became law and were supported by both the tribes and the state. Some opponents of this bill may argue that even though this bill is prospective over time, Congress may begin to erode the jurisdictional framework of the MIA. As members of this subcommittee, you know that's not how Congress operates. You write the federal laws pertaining to tribes in the United States, and the work of this committee does not produce controversial law changes that would introduce great uncertainty into the ability of any non-tribal member to manage non-tribal lands. You might also hear concerns expressed that this bill could create ambiguity and lead to litigation. On the contrary, let me tell you, anyone in Maine knows about how there has been repeated litigation between the state and tribes over the past 40 years, precisely because MIXA created ambiguity about the application of federal law. Our bill would eliminate this ambiguity in regard to future acts of Congress. That said, we remain very open to working with members of this committee and staff to improve this bill while staying true to addressing the problems it aims to resolve. All members of Congress, not just those from Maine, share the federal trust responsibility to these tribes. These are sovereign nations with a government-to-government relationship with the United States. With that, it is my true honor to introduce the Wabanaki Chiefs who are here to testify before you today. Chief Clarissa Sabatis of the Holton Band of Maliseet Indians, Chief Edward Peter Paul of the Micmac Nation, Chief William Nicholas of the Passamaquoddy Tribe, and Chief Kirk Francis of the Penobscot Nation. Madam Chair, Ranking Member, thank you very much for the opportunity to testify.
Thank you, Representative. Now I'd like to transition to our panel of witnesses for today. But before introducing them, I'm going to just remind witnesses they're encouraged to participate in the Witness Diversity Survey created by the Congressional Office of Diversity and Inclusion. Witnesses may refer to their hearing invitation materials for further information. Under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the on-screen timer will begin counting down and will turn orange when you have 1 minute remaining. I recommend that members and witnesses join remotely. Lock the timer on your screen. When you go over the allotted time, I will try to gently ask you to please wrap up your statement. After your testimony is complete, please remember to mute yourself to avoid any inadvertent background noise. I will allow the entire panel to testify before we question the witnesses. The chair now recognizes the Honorable William J. Nicholas Sr., who is the chief of the Passamaquoddy Tribe.
Willie Gizzy-Busquare. Good afternoon, Chair Fernandez and members of the subcommittee. My name is William Nicholas Sr., and I'm the chief of the Passamaquoddy Tribe. It's my honor to present testimony in support of H.R. 6707 and the Advancing Equality for Wabanaki Nations Act. H.R. 6707 is a narrow but critical reform of the Maine Indian Land Claim Settlement Act, a federal law which has been a significant impediment to Passamaquoddy self-determination for over 40 years now. The Passamaquoddy people traditionally occupied the area now known as Maine and New Brunswick, Canada. Our ancestors migrated seasonally throughout our territory. In the spring, we gathered plants for food, resided in villages located along the St. Croix River watershed to provide access to migratory sea-run fish such as pollock, eels, and salmon. In the spring, we gathered plants for food and resided in villages located through the St. Croix watershed to provide access to migratory sea-run fish such as eels and salmon, I said it twice. In the summer, we relocated to the wild blueberry barrens where our people could easily live off the natural bounty of the earth. In the fall, we headed to the woods where our hunters could harvest game such as moose, deer, and bear to sustain the people through the long winter. The Passamaquoddy way of life has confronted and survived numerous challenges since first contact with Europeans. In response to the pressure of colonialism, the Passamaquoddy were signatories to treaties with the British that predate the United States. These treaties are still recognized in Canada. We then signed the first treaty entered into by the United States following the Declaration of Independence, the 1776 Treaty of Watertown. Our warriors proudly served under General George Washington, and we still celebrate our military victories over the British in defense of what is now the United States of America. Despite these facts, the Commonwealth of Massachusetts and later the state of Maine considered the Passamaquoddy people to be state wards all the way up to 1975. State Indian agents manage our natural resources for their personal gain, and they administered nearly all aspects of life within our rapidly dwindling territory. Things changed in 1975 when the courts ruled that the Passamaquoddy tribe is a sovereign nation entitled to the protection of the federal government, just like any other federally recognized tribe. From 1975 to 1980, we established a government-to-government relationship with the United States and exercised all the attributes of a sovereign nation. Also during this period, the U.S. filed suit against the state of Maine for illegally taking Passamaquoddy lands in violation of the federal law. Our land claims were ultimately resolved in 1980 by the Federal Maine Indian Land Claim Settlement Act. The federal law approved a state law that essentially allowed Maine to exert unprecedented jurisdiction over our nations. It did not take long after the ink had dried before we started to see how the lopsided nature of the settlement would suppress more than support us. Yes, we received federal funds to reacquire a fraction of our ancestral homelands. However, we have been unable to acquire all of the lands promised under the Settlement Act. At the end of the day, though, The land and the money were not the biggest consequences of the Settlement Act. The real cost was our sovereignty, our ability to govern ourselves in our territory under tribal and federal law. Parts of the Settlement Act specifically blocked the Wabanaki Nations from accessing federal laws passed for the benefit of Indian country. A report prepared for the Maine legislature concluded that Congress has passed 151 such laws since 1980. This includes major laws enacted in the areas of healthcare, law and order, emergency services, and the environment. Congress enacted these laws to improve and enhance tribal communities. Nonetheless, the state of Maine, relying on the Settlement Act, fought to block these laws after benefiting tribal communities in Maine. Almost 10 years ago, the state tried to block one of the health centers from relying on the Indian Health Care Improvement Act to hire medical staff licensed outside the state. They also fought our efforts to pursue economic development under the Indian Gaming Regulatory Act. And when natural disasters hit our territory, we cannot simply contact FEMA-like tribes elsewhere in Indian country. Instead, we must work through the state of Maine because 2013 amendments to the Stafford Act do not apply to us under the Settlement Act. Today, the Passamaquoddy has two communities in the United States, Indian Township and Pleasant Point. Many Passamaquoddy people continue to sustain themselves and their families off seasonal work, including hunting, fishing, working in the woods, and raking blueberries. The tribe exercises jurisdiction over more than 100,000 acres of land. The area Passamaquoddy police officers and game wardens work spans east to west across Maine from the saltwater to Jackman, Maine. Whether it is enforcing our fishing game ordinances, providing tribal government services, or working to bring economic development to Passamaquoddy territory and surrounding areas, we are a sovereign government that is always working to protect, preserve, and improve the quality of life. At Indian Township, we employ 175 tribal government employees. We provide general assistance to both tribal and non-tribal members who reside on the reservation. We provide direct financial assistance to those non-tribal members who live in our community, yet, until very recently.
Thank you. If you could wrap up, we've gone a bit over.
Is that it?
Yeah. Did you have, go ahead and just wrap up with whatever your last two sentences would be. We're about 46 minutes.
The Settlement Act prevented us from holding such individuals accountable under VAWA if they broke our laws and committed acts of violence in our homes. This reality makes no sense. In 2022, it serves the purpose that, to frustrate the ability of the Wabanaki Nations to self-govern and pursue self-determination. Thank you.
Thank you so much, Chair, for giving us that extensive report on its impact on you. The Chair would now like to recognize the Honorable Edward Peter Paul, who is the Chief of the Micmac Nation. Chief.
Good afternoon, Chairperson of the Subcommittee. Greetings. My name is Edward Peter Paul. I am Chief of the Micmac Nation, whose lands are located in Aroostook County, the most northern county of the state of Maine. It's my honor to testify in the support of H.R. 6707, a bill advancing equality for Wabanaki Nations Act. The Micmac Nation is one of the 4 federally recognized nations located in the state of Maine, but is the only nation that is not specifically named in the Maine Indian Claims Settlement Act of 1980. In spite of not being a party or participating in the negotiations of the act, the U.S. court system later found that we had lost all of our jurisdiction to the state of Maine because of it. As a result, for the last 30 years, we are the only federally recognized tribe in the state of Maine that continues to be fully subjected to the state of Maine laws. For 30 years, we have been unable to negotiate a new jurisdictional agreement that gives us the legal authority to provide for health, welfare, and safety of our people. For 30 years, we have not been able to build our legal infrastructure, like a police department, a court system, etc. This current bill H.R. 6707, if enacted, marks the first time that our nation would be able to assume jurisdiction over our most precious resources, our children. It will allow us to start our nation-building efforts by helping us to create our first court system, a court system to oversee our Indian Child Welfare Act cases. We applaud Representative Jared Golden and the Wabanaki leadership teams that have worked so hard on this bill before you. We respectfully ask for your support. Willalen, Chief Edward Peter Paul.
Thank you so very much, Chief. We'd now like to recognize the Honorable Clarissa Sabates, who is the Chief of the Holton Band of Maliseet Indians.
Thank you. Good afternoon. My name is Clarissa Sabatis, and I'm the Chief of the Holton Band of Maliseet Indians. We're a federally recognized tribe located in Aroostook County, Maine, and we're a riverine people who have inhabited this territory since time immemorial. We call ourselves Wolastoqiyik, or people of the beautiful flowing river. And the Wolastoq, the river of our name, is also known as the St. John and is bisected by the international boundary with Canada. Our government-to-government relationship with the United States dates to the earliest days of our republic. The Maliseets, also known as the St. John's Indians, were signatory to the very first treaty entered by the United States, the Treaty of Watertown, on July 19, 1776. Our Maliseet ancestors, along with the Micmacs, agreed to send 600 of our warriors to fight alongside General Washington against Great Britain. And the United States solemnly promised to protect us and provide for us. More than 200 years later, Congress confirmed the Holton Band's status as a federally recognized tribe in the Maine Indian Claims Settlement Act. Despite the Treaty of Watertown and the 1790 Non-Intercourse Act, which prohibited any sale or transfer of Indian lands without a ratified treaty, Maliseets were unlawfully dispossessed of our lands. Beginning around 1870, the state of Maine encouraged the settlement of Aroostook County by offering land to non-Indigenous settlers at bargain prices. These settlers occupied our traditional hunting and fishing grounds and gradually excluded us from our Maliseet Aboriginal territory, which originally spanned more than 1 million acres. While we had neither signed a treaty ceding our lands to Maine or Massachusetts, nor voluntarily left our lands, by the middle of the 20th century, we were landless and treated as squatters in our own territory. In Mixa, Congress provided the band with $900,000 to acquire lands and natural resources along the Medexicag River, where we could rebuild our community and preserve our traditional riverine way of life. We have reestablished our community and preserve our traditional riverine way through, through gathering fiddleheads, brown ash, and here we continue to practice some of our traditional ways of life. While the passage of Advancing Equity for Wabanaki Nations, H.R. 6707, does not change the past, I would like to highlight how not being included in beneficial laws for Indian country intended to strengthen tribal nations has impacted us for decades. In Indian country, the authority of tribes to tax their own members on tribal lands is exclusive. One of the most fundamental principles of federal Indian law is that tribes and tribal members are not subject to state and local taxation activities on tribal lands. This does not hold true for the Holton Band of Maliseet Indians. We exist with no tax base to supplement government revenue, and Mixa makes our funding challenges even worse because we are not allowed to take advantage of economic development opportunities that Congress has passed. Not having full authority under ICWA that other tribes have stifles our ability to exercise jurisdiction and has created a cascade of ramifications for our children and families. We are denied one of the most fundamental rights as Indian tribes, and the impact of not having full authority over child custody proceedings under ICWA has resulted in the removal of up to 11% of our children in the past. Having access to ICWA, as it is intended, would allow for us to create systems where we could exercise our sovereignty and authority and build our courts and child welfare systems so that we know the future generations of our tribe are protected. Exclusive rights to hunt, fish, trap, and gather on Indian trust lands is an inherent right. However, this is not the case for the Holton Band. As a public health professional, I've had to advocate at the Maine legislature for small portions of moose permits to allow for our tribal citizens to hunt for this traditional food. Faced with disproportionate rates of diabetes and obesity and heart disease, moose offers a free and healthy food for our people. Unfortunately, the state legislature recommended that we have our citizens pay to be part of a larger state lottery to possibly get permits. The same legislature approved providing free moose permits for hunting lodges for economic development. Some of those go for in excess of $20,000. While our tribe has seen growth over the past 4 decades, we continue to struggle, due in large part to this restrictive settlement act that we live under. When the U.S. entered into MIXA, it unfortunately left our 4 tribes in an impossible situation and under the authority of a state that does not have the same trust responsibility as the United States government does. Unfortunately, that has been to the detriment of the health and wellness of our people. So, to address the question of why the state isn't here, we still have a unique trust responsibility, or the United States has a unique trust responsibility to our tribes. And I don't feel that we should have to ask permission or have the state involved in the relationship that we have. I think that is unique. And I'll stop there. So thank you.
Thank you, Chief Sabatis. Unfortunately, votes have now been called on the floor of the House, so we will need to recess and come right back as soon as votes are concluded. We all appreciate everybody's patience. We still have 4 witnesses, and then we'll go to Christians as soon as the recess is over. This hearing is now in recess, subject to the call of the chair. Thank you. so very much for your patience. I now call the subcommittee back to order. I'd now like to recognize the Honorable Joseph T. Byrd, who is the chairman of the Quapaw Nation. Chairman.
Hawaii, we huda jutse ogapa nikashi uda humpade. Good afternoon. My name is Joseph Byrd and I am chairman of the Quapaw Nation. I would like to extend my gratitude to the House Committee on Natural Resources Subcommittee for Indigenous Peoples of the United States, Chairman Grijalva, Vice Chair Garcia, Ranking Member Westerman, and other members of the committee. Madam Chair, thank you for your comments regarding Representative Young and honoring his legacy. I would also like to thank Representative Mullin for introducing this bill and for the support of our congressional delegation. I am here today to talk about H.R. 4715, a bill authorizing appropriations to the Secretary of Interior to make payments to members of the Quapaw Nation in accordance with the recommendation of the United States Court of Federal Claims. The impetus of H.R. 4715 is listed in the congressional findings of the bill, which I will reiterate for you now. On December 19, 2002, the House of Representatives passed H.R. 668, which referred H.R. 5862 to the Chief Judge of the United States Court of Federal Claims. H.R. 668 instructed the Chief Judge of the U.S. Court of Federal Claims to report back to the House of Representatives findings of facts and conclusions of law sufficient to inform the Congress of the nature, extent, and character of the Indian trust-related claims of the Quapaw Tribe and its tribal members for compensation as legal or equitable claims against the United States. These trust-related claims relate to the historical management by the federal government of the trust of the tribe. The hearing officer for the referral concluded in the report that it would be fair, just, and equitable to pay the claimants a total sum of $137,500,000 for all claims asserted or those that could have been asserted under the terms of H.R. 5862. Following the issuance of the report, each of the parties in the referral filed a notice responsive to the rules of the U.S. Court of Federal Claims and accepted the findings and recommendations of the U.S. Court of Federal Claims without exceptions. The review panel of the U.S. Court of Federal Claims adopted the findings and conclusion of the hearing officer in the report, and on January 9, 2020, officially recommended to the House of Representatives that the claimants be awarded and paid a total sum of $137,500,000 for the extinguishment of all claims actually or potentially included in H.R. 5862. H.R. 4715 was introduced and referred to the Committee on Natural Resources on July 27, 2021, and referred to the Subcommittee for Indigenous Peoples of the United States on August 9, 2021. On January 12, 2022, the Quapaw Nation Business Committee unanimously passed a resolution authorizing recommended changes to H.R. 4715 on behalf of the Quapaw Nation, and the House Committee on Natural Resources accepted the language and amendments to the bill. I come before this body today to testify in favor of the bill on behalf of the Quapaw people. The Quapaw Reservation, established by treaty in 1833, is located in the northeast corner of Oklahoma with a jurisdictional area encompassing 92 square miles of restricted, trust, and fee land. For those unfamiliar with the location of the Tri-State Mining District, the Quapaw Reservation contains what was once listed as the most toxic Superfund site in the country, Tar Creek. Following the Civil War, rich deposits of land and zinc were discovered below the surface of the Quapaw Reservation. Overnight mining towns popped up on the reservation, and over decades of extraction caused substantial damage to the land and water. The subsurface minerals extracted from under the Quapaw Reservation accounted for roughly 50% of the munitions of the United States during World War I and World War II. The war efforts of the United States during that period were made possible from the extraction of natural resources beneath the Quapaw Reservation. Much of the mining practices observed caused irreparable damage to the land and eventually the water inside the reservation, as well as the water that flows out from our reservation. To offer context of this contamination, the Boone Aquifer under Tar Creek originates in Kansas, flows to the Quapaw Reservation in Oklahoma, and empties into a tributary of Arkansas. As I drafted my statements for today, I sat beside my 92-year-old grandmother as she enters the last leg of her journey on this earth. Ardina Rivard Moore, Moshongite, or Eagle Feather gets up, sends a message to Congress. She wants to know when she's going to receive her chat check. That's what she, along with other tribal elders, commonly refer to this appropriation as. They are the originators of this action, and we continue to lose them daily as they hang on to the hope that the federal government will again honor our treaties and the federal trust responsibility. Honoring treaties with tribal nations is a basic tenet of federal Indian law to which I will not belabor this committee. I will, however, impress upon the committee the environmental nature and basic human element to this issue. In closing, I would like to thank the Quapaw citizens who chose me as their leader to present this matter before the United States. It is an honor, and I acknowledge this privilege. It has been an honor to testify before this committee today, and I welcome any follow-up questions. Ekohe and Gunage. Thank you.
Thank you, Chair of the Quapaw, and thank you so much for sharing the words of your grandmother. Please let her know that Congress did listen. I'd like to now recognize the Honorable Kirk Francis, who is the Chief of the Penobscot Nation.
Thank you, Madam Chair, and good afternoon, everyone. Thank you for inviting me to testify on H.R. 6707, the Advancing Equality for Wabanaki Nations Act. The Penobscot Nation is one of 4 federally recognized Wabanaki tribes in the state of Maine. We have approximately 2,400 citizens and are on over 123,000 acres in the state of Maine, which include about 220 islands located within the Penobscot River. In the 1980s, the Wabanaki Nations entered into settlement agreements with the state, which the federal government ratified through the passage of the Maine Indian Claims Settlement Act. These acts resolved various land claims by the tribal nations and generally made the Wabanaki Nation subject to state civil and criminal jurisdiction. The federal act also contained a provision, Section 6H, that prevented any existing federal law enacted for the benefit of Indian country from applying to the tribal nations in Maine, if such law affects Maine law. There is no definition of the term affects in the Settlement Act, and as a result, the definition is overbroad. Additionally, while the federal bill was pending in the Senate, an additional provision, Section 16B, was added without the Penobscot Nation's consent. This provision restricts federal laws enacted for the benefit of Indian country after 1980 from applying within the state, unless the law expressly includes the Maine tribes. Those 2 provisions have created uncertainty as to which federal laws are applicable to the tribal nations in Maine and which are not. Also, the state can prevent any federal law from applying in Maine by merely claiming that it affects Maine law. I want to share 2 examples of the harms these provisions have caused the Penobscot Nation. First, we have not been able to access major disaster or emergency assistance directly from FEMA through the 2012 amendments to the Stafford Act. These amendments allow tribal governments to submit requests for major disaster or emergency declarations directly to the president, without having to go through states. We have not been able to benefit from these amendments because the law did not expressly include the Maine tribes. And a Senate colloquy confirmed Congress's intent on this matter. As a result, when the COVID-19 pandemic hit, we were not able to receive assistance directly from FEMA, but instead had to work through the state. This delayed getting federal assistance to us, created additional red tape and bureaucracy during a health emergency. My second example is the Violence Against Women Act, whose 2013 tribal amendments did not expressly include the Maine tribes. Therefore, these amendments did not apply to the Maine tribes because the state said such provisions affected Maine law. Because of this, our court could not utilize the special domestic violence criminal jurisdiction over non-Indian offenders and was not eligible for pilot program funding, which we were selected for. We lost out on millions of dollars that would have strengthened our tribal court and public safety efforts. After 9 years of advocacy, we were finally able to get Congress to expressly include the Maine tribes in the most recent VAWA bill. If 6707 does not pass Congress, we will have to spend significant resources and time to get the Maine tribes expressly included in every federal bill that Congress considers moving forward. We do not have these kind of resources available, and we believe it is a violation of the federal government's trust responsibility to require us to do this. When Congress passes a law intended to benefit all of Indian country, we think that is what should happen. unless a tribal nation or a state is expressly excluded from the law. Expecting the Maine tribes to have to get ourselves added to every federal bill is nonsensical. And our recent efforts with the VAWA bill shows how unreasonable it is to require us to do that for every bill. We are not asking Congress to change the overall jurisdictional framework that exists between the Wabanaki Nations and the state. That is a separate effort, and we are working with the state on these issues. All that we are asking Congress to do is address this one issue and to revise the Federal Settlement Act so that the default is that Maine and our tribes are included in any federal law enacted for the benefit of Indian country, unless there is language expressly excluding us. And we only come to you with this ask after the state task force and Attorney General concluded that such a change couldn't effectively be done through our current efforts at the state level, but has to be done in the Federal Settlement Act with the United States Congress. Additionally, HR 6707 only addresses the application of future laws passed by the Congress to benefit Indian country, and not the application of any existing federal law. We think this is fair, and we believe it is consistent with the federal government's trust responsibility to Wabanaki Nations and Congress's intent when it passes laws for the benefit of Indians. Thank you again for this opportunity, Madam Chair, and I appreciate being here today and willing to answer any questions.
Thank you so much, Chief Francis, for your testimony. I would now like to recognize Mr. Charles P. Rose, who is the chair for the Board of Trustees of the Morris K. Udall and Stewart L. Udall Foundation. Mr. Rose.
Sorry about that. Good afternoon, everyone, and thank you, Chair Ledger-Fernandez. Thank you, Vice Ranking Member Obernolte, and thank you to members and staff of the Subcommittee for Indigenous Peoples of the United States. I would also like to extend our gratitude to Chairman Grijalva for sponsoring HR 5715. As was mentioned earlier, the Morris K. Udall Foundation was established by Congress in 1992. It was established as an independent executive branch agency to honor Morris K. Udall's lasting impact on this nation's environment, public lands, and natural resources, and his support of the rights and self-governance of Native Americans and Alaska Natives. In 2009, Congress enacted legislation to also honor Stewart L. Udall's for his half-century of distinguished national leadership in environmental and Native American policy. The agency is now known today as the Morris K. Udall and Stewart L. Udall Foundation and is headquartered in Tucson, Arizona. The Udall Foundation is governed by a board of trustees comprised of 13 members. 9 trustees are appointed by the president with the advice and consent of the Senate, and 4 trustees are designated by law and include the chair of the Council on Environmental Quality, the president of the University of Arizona, and the secretaries of the Departments of the Interior and Education. In the Foundation's 30-year history, we have awarded $9.59 million in scholarships to 1,788 undergraduate students. We have funded 295 Native American congressional interns who have served in 68 legislative and executive branch agency offices. We've funded 33 graduate fellows from 19 colleges and universities, including the subcommittee's own Representative Stansberry, who was a 2009 Udall Fellow. We've served 5,577 of our nation's youth with 10,280 hours of activities through our Parks and Focus program. We've produced 412 publications and given 702 public presentations through the Udall Center for Studies in Public Policy at the University of Arizona. And we've also provided Native Nation building services to 62% of this country's federally recognized tribes and supplied almost 400,000 pages of Indigenous governance database material through the Udall Center's Native Nations Institute program. The original Udall Foundation enabling legislation has been amended 6 times since 1992, most recently in 2019. HR 5715 will further amend the enabling legislation in 2 respects. First, authorize appropriations to the Udall Foundation through fiscal year 2029. And second, to specify that $5,000 in annual appropriations to the Environmental Dispute Resolution Fund may be used for official reception and representation expenses. An authorization of appropriations to the Udall Foundation through FY29 will allow the agency to continue its congressionally mandated mission to foster leadership, education, collaboration, and conflict resolution in the areas of environment, public lands, Native nations, and natural resources. It'll allow us to support the development of self-governance, to strengthen Native nations, and it will also assist federal agencies and others to resolve environmental conflicts. The increase in the limitation on the official reception and representation expenses to $5,000 does not require an increase in appropriations. It only adjusts the cap to reflect the real costs of the agency's work to increase the appropriate and effective use of environmental collaboration and conflict resolution principles across the federal government, including in accordance with 2012 OMB CEQ Joint Memorandum on Environmental Collaboration and Conflict Resolution. We appreciate your courtesies. We also appreciate the kind words that were mentioned at the outset of this hearing by the Chairman Ledger Fernandez, as well as the Vice Ranking Member Obernolte. And I'm happy to answer any questions that the committee may have. Thank you again.
Thank you so much for your testimony, Mr. Rose. I would now finally recognize Mr. Patrick Stroach. Sorry if I didn't say that correctly, who is the Executive Director for the Maine Forest Products Council. You are now recognized.
Thank you very much, Madam Chair Fernandez and the subcommittee members. I am Patrick Strout, the Executive Director of the Maine Forest Products Council. I appreciate the opportunity to testify on HR 6707. The Maine Forest Products Council represents around 32,000 direct and indirect jobs in rural Maine with all aspects of the forest economy, including sawmills, pulp mills, and over 8 million acres of commercial forest land dues-paying members. HR 6707 would amend the Maine Indian Claims Settlement Act to gradually reverse Section 6H and to repeal Section 16B. These are critical provisions of that settlement legislation. Section 16H confirms the application of state jurisdiction over tribally held land and natural resources. And Section 6B insulates the jurisdictional framework from unintended disturbances by Congress. For more than 40 years, we have passed, since 40 years, this has passed, Congress has enacted the settlement and approved its state companion, the Maine Implementation Act. The application of state jurisdiction has provided a reliable and predictable framework within which all those involved in the forest products industry have been able to manage their forests and manufacture wood products while meeting their obligations to be stewards of the land. I provided a map in my testimony that shows the tribally held lands are spread across all of central and down east and parts of northern Maine. Many of these lands are adjacent to members of mine, and we've worked on this relationship with the tribes in a shared commitment to managing natural resources. Likewise, many of my mills share river resources adjacent to tribal lands, and we've worked over the years with the state and the tribes to balance discharge licenses with sustainable fishing standards. We value these relationships, even though we must reluctantly oppose HR 6707 for the following reasons. First, we do not believe this is narrow legislation. Although it would not displace state jurisdiction overnight, it would surely do so over time. Under HR 6707, each new federal Indian jurisdictional statute and each reauthorization of the laws, including treatment and state status for Indian tribes, would apply in Maine. It might take years, but eventually most or all of our Maine state jurisdiction over tribal lands and natural resources would be displaced. With respect to environmental regulation, which is the thrust of our concern, If the tribes attain treatment as state status, and a two-tiered system would emerge where we'd have to meet state environmental standards, which are strict and demanding as they should be, and tribal standards, which could be much stricter. Such a system would bring great uncertainty and complexity to the forest products sector. Second, we are concerned about some aspects of the bill that are unclear. It would apply to statutes, but we're not clear how it would apply to the enormous body of court decisions that comprise the foundation of much of the federal Indian law. If it does apply to federal Indian case law, it is not clear whether the whole body of federal Indian case law would apply upon enactment, or like statutory law, would be phased in gradually. We don't know the answer to this. We ask that the subcommittee examine it closely. Third, when Congress passed the Claims Settlement Act, it understood the circumstances of the state of Maine and the tribes would change over time. And therefore, Section 6E, it gave consent to the Maine legislature to amend the implementing act, provided the tribes consented. And at several points in the last 40 years, the state and the tribes have relied on this consent to amend the implementation act. In fact, right now, the legislature is very busy considering the proposed amendments to the Maine implementing act. Fourth, we are concerned there is no indication that the state of Maine, either through its executive, Governor Janet Mills, or its legislature, or both, has consented to this bill. When Congress approved the Maine Indian Claims Settlement Act, all parties, the tribes, the state, and the United States consented to it. We believe this precedent should apply to 6707. We therefore respectfully ask this committee not to approve 6707 without a clear confirmation from the state that it consents to it. Thank you for this opportunity to testify, and I'd be glad to answer any questions you may have.
Thank you, Mr. Stock, for your insights and sharing of your testimony today. We will now move on to our member questions. I want to thank each of the panelists for the testimony. I want to thank you for your patience as we went and did our duty and voted on the floor of the House. I will remind the members that Committee Rule 3D imposes a 5-minute limit on questions. The chair will now recognize members for any questions they may wish to ask the witnesses, and I'll start by recognizing myself for 5 minutes. So today, I think that what strikes me about the bills as I'm listening to them is I heard a wonderful thing that said we must be better ancestors than we are descendants. And so thinking in that role of what are we doing for those generations that come afterwards, I wanted to sort of ask a few questions of Chief Sabates and Chief Peter Paul. As we've heard today, the Advancing Equality for Wabanaki Nations Act would make sure that future Indian laws apply to the Wabanaki tribes. It will also apply the Indian Child Welfare Act to 2 tribes in Maine, the Houlton Band of Maliseet Indians and the Mi'kmaq Nation. Can you just describe briefly how the absence of the Indian Child Welfare Impact Act affects youth and others in your community as we think about how are we preparing to be good ancestors?
I'll go first if you don't mind, Chief Peter Paul. So for us, it does apply to 2 of the tribes in Maine. We're really looking for some equity as far as that goes, but it really leaves us vulnerable and at the mercy of individuals a lot of the time. And I've had to spend a lot of time advocating with local Department of Health and Human Services employees, as well as state leadership for funds that should be coming to the tribe, but that go to the state instead of us, advocating for families. We don't have the authority at this point to really be involved until DHS decides that they're going to remove children. And there's a lot of barriers to placing children within Indian families if there has been a removal, because the state is the authority that inspects homes. Even though we have that authority, it's only for Indian custodianships, which is a different creature. So really we haven't been able to even establish a structure so that we can exercise that sovereign right or authority.
Thank you, Chief. Would you like to add any more to that?
Yes, I would say that, a lot of times we're not aware of, what DHS is doing after they do it, and I'm not saying that it's that way all the time, but a lot of times we don't know, and we don't get the family, we don't get the children placed where we would like to see them with Native families. That's not always possible. And, that takes away from the overall tribe in general, not being able to raise its children how it sees fit. We've gone through this truth and reconciliation, and we all know, what goes on in the outside, in the world outside of how we raise kids, is what I'm trying to say. But I think it's important for us to have that say in how our children are taken care of.
Thank you so much, Chief. And I'm now going to move over to Mr. Rose. As we talk about serving Native youth, you gave us an impressive compilation of all the different programs you've done. Those of us from New Mexico, from the rest, know well the great work of the Udall Foundation, the great work of the families, the wonderful family of Udalls that we have been blessed to have participate in our issues. So I really wanted to zero in on the way in which your work helps in terms of representation, in terms of creating opportunities for Native youth to grow and learn so they can advocate for and lead their communities. So when you're thinking about that, how does the foundation improve representation of Indigenous peoples across government, business, and other sectors? And how do you measure what kind of success you're having in terms of the impact on the larger Native American communities?
Thank you, Chair Ledger Fernandez. And on a personal note, it's an honor to serve on the board and in particular serve as the chair. When we think of your question, we think of our internship program, our fellowship program, our scholars program, those programs that are focused on education in particular, and the strong relationship that we have with the University of Arizona through the Native Nations Institute and the Udall Center for Public Policy to support those education programs. So, for example, the internship program that we have supports the placement of 12 Native students in House and Senate offices, on congressional committees, and in executive branch agencies for 10 weeks each summer. There are about 300 alumni from that internship program. And the exposure that those interns have to our process here in the United States is inspiring. And many have gone on to leadership positions at all levels of government.
Thank you, Chairman Rose. I have run out of time, and thank you very much. We do know that the interns, I love those stories of, well, I started as an intern and now I'm the Congress person. So we look forward to having more of that occur with the Native youth that use the Udall Foundation. The chair would now like to recognize our designated ranking member, Obernolte, for 5 minutes.
Thank you very much, Madam Chair, and thank you to the witnesses. I'd like to start with Chairman Byrd. You were talking about the need to pass House Resolution 668 in the 112th Congress, and I wondered if you could go back and give us a little bit more detail about why that was necessary and about some of the claims that were made in HR 5862 that created those trust claims against the United States.
Thank you for that question. Sorry, I had to unmute myself. So I referenced back on December 19th, 2002, the House of Representatives passed HR 668. And it was a congressional reference at that time and HR 668 essentially instructed the chief judge of the U.S. Court of Federal Claims and report back the findings, facts sufficient to inform Congress of the nature, extent, and character of these claims. And these claims really, from the outset, were caused by years upon years of damage, damage to the property, damage to the land, damage to the water, and even damage to the air quality, and still continues to be severe to this day. And so some of those claims that were initially reported in that report have to do with directly the damage to the property. And, we're all familiar with individual Indian allotment land and, some of the federal grazing and responsibilities that go with that. And really what that boils down to in terms of the time, the mismanagement of the land has to do directly, it ties with the theft of lead and zinc. And the lead and zinc that was found during that time was barred by the statute of limitations. So that was the impetus to create the congressional reference.
Great. Well, thank you very much for that. And then going to Mr. Strach, talking about the Maine Indian Claims Settlement Act, which I know you're knowledgeable about, can you walk us through how that was negotiated? I mean, did the tribes have to settle those claims? Could they have taken their chances in court afterwards? And did they get what they were seeking in that settlement?
Well, I wasn't there, but I believe that that there were the tribes were very well represented. They had a strong team of attorneys. I think that there was the option to walk away. There are others that are more familiar. My attorney, Tim Woodcock, is actually one of the staff people that worked with Senator Cohen in putting together the Tribal Act claims. But my sense was that there was the opportunity to walk away. The tribes received funding for the lands which they subsequently purchased in mosaic across the state of Maine, and there were provisions that I think everybody at the time was in agreement on. The testimony is available in the record to take a look at that and to reconstruct all those events.
Okay, well, I saw some of the other witnesses shaking their heads no during the testimony, so hopefully we'll get some more time to explore that. Are there other instances that you know of where Congress has enacted legislation that materially alters the terms of one of these state settlement acts without obtaining the express approval of not only the tribe but also the affected state?
I'm not aware of, based on our research. There may be some situations, but the Eastern tribes are, the settlements that are made in the East are particularly of interest and complicated and different from other parts of the area, but I'm not aware of that.
All right. Well, thank you. I'll yield back and hope we get some time for some questions later.
Thank you. The chair will now recognize Representative McCullum for 5 minutes.
Thank you. And Madam Chair, I could go on about Representative Young, but thank you for your words and your moment of silence. And I'll leave it at that because he'd want me to cut to the chase. I just want to tell a story of something that I found very shocking. I had the honor and privilege, both as a state legislator, a member of Congress, to work for over 30 years with tribes of Mast, especially the tribes of Minnesota. And now I have the honor and privilege of working with tribes from all over the country, Alaska Natives and Native Hawaiians. When we passed the Violence Against Women Act, and we were working hand in hand with tribes for partnership, and when Maine was put in as a pilot program, the whole Congress voted to give Maine that opportunity to work with its tribal governments, sovereign nations, in my opinion, and money was given to do a pilot project in Maine. And the state of Maine just refused to participate. And I was outraged by that. I'm not a person who's big on preemption, but I really felt the state of Maine preempted the federal government from working in partnership with tribal sovereign nations in Maine to uphold their obligation to protect the families, the women in the Violence Against Women Act. So I'm going to turn to Chief Francis and ask you some questions. There's been much said about working with the state of Maine. So the state of Maine, when they're working with tribes on changing any of these things, it's Maine taxpayers that are footing the bill. When you go to court to defend yourself, who's paying that bill? Are the taxpayers of Maine also representing you in court, or are you having to come up with the funds yourself against the entire state of Maine?
So as we sit here, thank you, Representative. It's great to see you again. It's a great question, and no, Maine taxpayers are not paying for our legal defenses. We have to depend on the limited resources we have. We also have depended on some great programs like litigation assistance, if we can obtain it, those types of things to get help to try to defend ourselves against a lot of these things. As we sit here today, we have a Supreme Court petition that is a result of what I consider a territorial removal in Maine, deeming that 60 miles of our reservation is no longer our reservation, to block our rights to exclusively manage our sustenance-based rights. So it's been a challenging 40 years in that area, and a tribe with limited resources that's been blocked from things like IGRA, like a host of other economic opportunities. It's been challenging.
So thank you for that. So you're constantly fighting for your rights. In Minnesota and in parts of Mast area, we had on allotment where the lumber barons and the railroad barons came in and passed a special bill in Congress and basically, except for Red Lake Nation, divided tribes and scattered them into the patchwork quilt that we're seeing in Maine. But the tribes in Minnesota have been able to put back together portions of their reservation. And I don't see how that would ever be possible in Maine. So I want to take baby steps and see how this works and see if we can reach some settled negotiation. Therefore, I very much support the bill that's in front of us today. It's not a clawback. It's a way to move forward. We cannot have a group of tribal nations be treated differently with their sovereignty than other tribal nations in this country. And that's how I come to be of the opinion I am. Miigwech.
Thank you. The chair will now recognize Representative Carl for 5 minutes. Representative Carl? We will now move, and Representative Carl gets here later. We can go back to him. In that case, we will now move and recognize Representative Case for 5 minutes.
Thank you, Madam Chair. And first of all, to all of the testifiers, aloha from your brothers and sisters, the Native Hawaiians, the indigenous peoples of our country who originate in Hawaii. Let me ask a couple of basic questions, and I'm not really sure who best to ask, but I'll just start with Chief Nicholas, I suppose. and let me make some observations and get confirmation. So my understanding is that the tribes are federally recognized. They have the same basic government-to-government relationship that is enjoyed by hundreds of other tribes throughout our country, that comes with a long, history and tradition of Indian law, as we say, that this involves the exercise of sovereignty under federal law over lands and other resources, but that effectively, in this case, federal recognition comes with an asterisk. Would you agree with that?
Yes, I would agree. I think the Land Claim Settlement Act was intended to recognize the sovereignty of the tribe and come to an agreement within the state of Maine that that was so heated at the time, and be able to work together. And it's been one-sided all the way through.
Okay, well, here's my basic, and I understand further that if you look at all of the federally recognized tribes, there aren't that many asterisks out there where essentially the recognition is there. The law says that there is a government-to-government relationship, but there is really effectively a carve-out from your ability to exercise the same sovereignty over your lands and resources, as is true with most other federally recognized tribes. So, do I have that straight?
Yes, I believe so. We do have a government-to-government relationship with the federal government. Yes.
Okay. I guess maybe I'm going down the same lines as my colleague and friend Ms. McCollum, but I don't see how federal recognition is federal recognition unless there is the exercise of that sovereignty over lands and other resources of the tribes. And so this one's a puzzle for me. And I get that there would be, I guess, historical reasons why it was enacted then, but that doesn't necessarily mean it's the right way to go today. And as I understand it, the land claims were extinguished in return for essentially the promise of resources with which to replace those land claims with other lands, and that hasn't fully happened yet. Is that right?
That's correct. We haven't been able to reacquire property from that original agreement in full.
Okay, so I mean, essentially, the way I look at it is there was some kind of an agreement that was sanctioned by federal law several decades ago, which has never been fully implemented. Is that correct from your perspective?
Yeah, it's never been fully followed by the state of Maine in agreement with the Maine Land Claim Settlement Act.
Okay, and I'm sorry, Strouch, right?
Yes.
I tried to listen closely to how you were pronouncing your name. I guess my observation here is that there is probably no state in the country that is fully comfortable with the ceding of jurisdiction over lands. I mean, that was the nature of the deal for federal recognition. In the big picture was that our federally recognized tribes would in fact be able to exercise some form of limited sovereignty separate and apart from the states. And so we see this across the board in areas such as, Indian gaming is one example, which was by federal creation, but also others by federally sanctioned treaties. And so I hear your concern about the state of Maine not sanctioning this, but I don't think they ever would, because why would the state of Maine want to give up jurisdiction over what it views as state lands? And so from my perspective, in that case, it does become a call by Congress as to which way to go on it. And I wanted to give you the opportunity to comment on that. I'm not surprised at your comments, but that's the nature of federal recognition.
Yes, no, I appreciate that, Representative. I think in Maine, I'm focused on the environmental aspects of the legislation. And in Maine, a lot of the expansion of the tribe was in parcels that are scattered throughout the region. It makes a very different kind of arrangement than I think perhaps in other tribes. If you have sovereign rights on multiple acreages scattered throughout Maine, it creates a complicated management and legislative kind of
Yeah.
regulatory approach.
My chair is about to cut me off because she's very strict on these things, but I would just make the comment that we've managed to work that out elsewhere in the country, that particular issue. So anyway, thank you so much, and I yield back.
Thank you so much, Representative Case. And yes, the checkerboard is an issue that is repeated in state after state. The chair would now like to recognize the gentleman from Alabama. Mr. Carl, are you now on with your camera?
I am. Thank you, ma'am. Madam Chair, I would love to yield my time to Congressman Obernolte, if I could, please. It's going to get straight in my mouth sooner or later.
Representative Obernolte.
Well, thank you to the gentleman from Alabama for yielding. You know, this is kind of an interesting discussion we've been having about this bill. You know, a situation where we've got a settlement agreement between a state and the tribes that's been ratified and followed by the federal government. And now the question before us is, should the federal government reach in, preempt state's jurisdiction over that, and alter that agreement? So, I mean, there's been some compelling arguments on both sides. Mr. Strach, I'd like to go back to what you were talking about just a minute ago, when Congressman Case asked you why Maine would ever consent to this. I mean, first of all, they could consent, right? I believe that they could go in and modify the state act if they wanted to consent to some of the provisions the tribes have been arguing. Is that right?
Yes, we're in the middle of that right now in our legislature, as a matter of fact. Section 6E of the agreement gives a consent to the Maine legislature to amend the implementing act, provided that the tribes consented. So there's a mechanism there. We are using that mechanism, and we're exploring the possibilities of trying to make changes to the act. Congress passed the act understanding that circumstances would change.
Mm-hmm. And well, Congressman Case made a good point as to, you know, why would a state ever give up jurisdiction? But I think some of the other questions is, for example, Congresswoman McCollum was asking about a pilot program that could have resulted in millions of dollars flowing to the tribes. We've heard multiple tribe chairmen and chiefs testify that they would like to deal directly with FEMA to get emergency funding flowing to their tribes. I imagine the state, you know, wouldn't have any objection to that. So, you know, is it the case that the state doesn't want to give up, you know, the jurisdiction at all, or is there just some disagreements over the management of the lands in particular that's causing the problem here?
Those are not my areas of expertise, but I would say that we're aware of the tribes making requests, and the process is available to follow. Again, I'm focused on the environmental laws, but the mechanisms are there.
Yeah, okay. I mean, I don't see, I served, as many of my colleagues on the panel here, I served in the state legislature for quite some time, and you know, we would from time to time deal with these issues. And of course, why would we want to stop money coming into our communities, particularly our tribal communities? So, I mean, that's part of the problem that I have with this particular bill, and the mechanism that we're using is that I wish we would give the state of Maine the time to kind of negotiate these issues, so that, you know, to really tunnel down on what the areas of disagreement are. And of course, I mean, let me ask this question. So if this committee and then following this, you know, the entire Congress were to take this step and pass this bill without the express consent of the state of Maine, do you think that this would set a precedent for Congress taking the same approach to other settlements agreements with other states and their tribes?
Yes, I do. I think we all entered into this agreement in good faith. There may be some that feel like it was unfair. The record shows that all the people that were involved in the agreement were in consensus, just based on what I'm reading in the congressional record and the reports of the issue. So this would be, I think, a dangerous precedent to be working against all those parties that were originally involved. And I know our governor has been working very closely with the tribes and has intimate knowledge of the issues that they're facing, and has actually been the Attorney General working on water quality and river ownership issues with the tribes over many years. So we're not naive to the process, and the state wants to, I'm sure, I can't speak for the state, I can speak for the forest industry. We're, of course, interested in the tribes receiving all the benefits that they can receive. We're just cautious about how are we going to put all the pieces together to deal with the business community, the environmental regulations. It took a lot of negotiation to put this original deal together. It's going to take negotiation to figure out how to revive it, and that's happening right now.
Right. Well, I agree. And I think everyone on this panel and in this committee is interested in getting all of their federal resources that are due to these tribes to where they need to go. No one is talking against that. But Madam Chair, in hopes that maybe as this process continues, we can find some way of navigating this that gets those resources to the tribes without overriding the jurisdiction of the state. I yield back.
Thank you very much, Representative Obernolte. And now I will turn to the gentleman from Illinois, Representative Chuy Garcia.
Thank you, Madam Chair and the Ranking Member, and of course to all of our witnesses. Over the last 2 years, this committee has held hearings on the inequities that we've witnessed in Indian country before and during the pandemic. We've discussed the inadequate resources and funding, devastating statistics, the impact on Native children, and more. Now, imagine being excluded completely from the healthcare programs and emergency relief, unlike federally recognized tribes in every other state. This has been the case for 4 tribes in Maine. And while this is a far from my hometown, we should all care and be concerned when any community is completely excluded from basic fundamental rights. For the Honorable Clarissa Sabates, thank you for joining us today, Chief. Can you share how COVID impacted your community compared to other tribes in the U.S.?
Yeah, sorry. We actually are still really, I think we responded quickly, I will have to say. All the tribes here in Maine responded very quickly. And as a public health professional and a registered nurse, as soon as we had our first case in Maine, we completely shut everything down. So I think that some of those things really helped. However, again, as Chief Francis mentioned, it really was difficult to figure out the avenues that we needed to work through when it came to FEMA and our declaration and all of those things. So we're still, for myself as a leader, it was very convoluted. So I struggled in the beginning to figure out how we were going to navigate these things. I think as far as vaccinations and things like that, we really had good systems, and we stayed on top of things, and we were able to bring in private resources that were non-governmental as well. So I think we did okay. And, you know, people listened, they're getting vaccinated. So I guess that's all I have to share for that.
Okay, thank you. And in your testimony, you described that the Advancing Equity for Wabanaki Nations Act is a narrow bill that applies only to future laws and new programs created by Congress. What are some of the benefits provided to other Indian tribes that the Wabanaki nations would still be excluded from?
Oh, geez. I would say, for us at least, ICWA is one of those big ones, and it really, even in Maine, it's not equitable for us. We're 2 of the 4 tribes that aren't able to exercise our full jurisdictional authority, and so it's a real struggle. You know, when we're trying to protect our children. I think that I'd also heard IGRA mentioned, and you know, we're going through things here, and that wouldn't change the current current things that we're working on, but it really is a struggle to have to fight and devote resources, sometimes for years, for things that other tribes just have the ability to do.
Thank you for that. Got about another minute or so. Wanted to ask you if you could describe this bill as being, quote, critical to the self-government and self-determination of the Wabanaki Nations. Can you share more on the importance of self-government and self-determination for tribes and why this bill is the first step towards achieving this?
Self-determination and self-governance is everything. I mean, these are the things that should be inherent to us. And you know, with the act that we live under now, it is really a challenge. And I think that it actually creates more question, and we do end up in court with that. So for me, to be able to take care of our people and do it in the way that we see fit, and not have to ask other governments, ask a state to be able to do things that we should just be able to do under our federal recognition and under, or being sovereign nations, is really difficult. Again, I know that it was mentioned about resources, but we really have to take so much time and devote so many resources just to be able to do things that are just simple and should not be difficult.
Thank you so much. I've run out of time. Madam Chair, I yield back.
Thank you very much, Representative. So before we conclude this witness panel, want to make sure, has anybody else come online that would like to ask questions? Hearing no one.
Madam Chair?
Yes?
At one point, you said there might be a possibility for a second round with votes and everything coming up. Is it my understanding that this is the only round we're going to have?
Yes, this is the only round we're
Thank you. Thank you for the clarification.
Thank you, Representative. So in that instance, I would like to thank the witnesses for their valuable testimony, for their sitting for questions and giving us more insight into what are the issues at play here for all the bills that we've considered. The members may have additional questions for the witnesses, and we will ask you to respond to those in writing, and those will become part of the record. As I stated before, we'll have the need for any witnesses to go back and forth with written questions. Under Committee Rule 3.0, members of the committee must submit those witness questions within 3 business days following the hearing, and the hearing record will be left open for 10 business days for these responses. If there is no further business, without objection, the subcommittee stands adjourned.